Good afternoon. It is my pleasure to moderate this panel. My gratitude to the Nuremberg Academy and to the Center for Human Rights for the invitation, and also for the opportunity to contribute to a conversation that is sadly very, very relevant for many around the world. As an example, according to the National Unit for the Search of the Disappeared, in the past 7 days, and in the framework of social protests, 379 individuals have been reported as disappeared in my country, Colombia. Let me start by saying that I could not be in better company to address this topic, the topic of this panel, historical origins of the crime of enforced disappearances and its legal concept. Barbara Frey and Emilio Crencel's contribution to the development, knowledge, acknowledgement, legal and social documentation and investigation of enforced disappearances in the Americas is second to none. Welcome, Barbara. Welcome, Emilio. Buenos días.
Buenos días. Gracias.
Thank you for being here with us today. So, to take as much advantage as possible from their presence here today, rather than hearing a presentation from each of them, we're going to use the time that we have been allocated to have a Q&A. And you are all very, very welcome to submit your questions through the Q&A function on your screen. So, enforced disappearances is, in my view, one of the most complex crimes and grave human rights violations that we face today. And to ensure that we all depart from the same understanding of the legal concept that we have nowadays and can better appreciate its development through what our panelists will share with us, let me start by quickly unpacking the UN definition of enforced disappearances. So first, we're talking about an arrest, detention, abduction, or any other form of deprivation of liberty. Second, this deprivation of liberty is conducted by agents of the states or by persons or groups of persons acting with the authorization, support, or compliance of the state. The third element is the refusal from those responsible to acknowledge the deprivation of liberty or by concealment of the fate or whereabouts of the disappeared person. And it is the combination of these three elements that places the victim outside of the protection of the law. Now, beyond the definition, but of course, as a direct consequence, the relatives of the disappeared person are unable to get any answers from the authorities and are therefore somehow, to some extent, also outside of the protection of the law. This is a crime that has therefore a clear beginning, but no clear end, which is why in its general comment, the UN Working Group on Enforced or Involuntary Disappearances call it a prototypical continuous act. The complexity of this crime in terms of the impact that it has on the victim, the extent to which it instantly changes the life, the plans, the projects of relatives and loved ones, the way in which it fractures the confidence of society in the authorities, and the difficulty to get the state to investigate its own, and at the same time search for the victim, because of course the victim has the right to be searched for, has clearly shown the need to look beyond the legal profession to address this violation, both at the domestic and the international level. This is also true when enforced disappearances become a systematic or generalized attack and potentially fulfill, with the complexities explained by our keynote speaker, the contextual elements of crimes against humanity. And just for those of you that are interested in this last scenario, I wanted to mention as an example, the International Federation for Human Rights recently submitted a communication to the International Criminal Court regarding the ongoing disappearances in the state of Coahuila, Mexico. This report is available online, and I'll be happy to share it with you in the chat later on. Okay, so now let me turn to our panelists to address the development of this concept from their own experience and the different fields of knowledge that they bring to us here today. Emilio, while enforced disappearances have not only taken place in Latin America, Argentina is a worldwide reference. You are a sociologist by training. Will you share with us your encounter with enforced disappearances? How did you come across this topic? How did your work started? The floor is yours.
Good morning. Thank you very much, Veronica, and thank you for the Center for Human Rights and the International Nuremberg Principles Academy for the invitation for this conference. It's a privilege for me to be here, to be there. And it's a pleasure also to share with Barbara and you, Veronica, the panel. In Argentina, academic studies on disappeared and disappearances appeared in the middle of the 90s. It was a time in parallel when memory became the focus of academic research, particularly of studies dealing with political violence and the last dictatorship. At this time, I recall that appeared an original political phenomenon, the victory in the election of governor of the province of Tucumán of the General Domingo Bussi with 46% of the votes. Bussi was governor of Tucumán under the dictatorship and was responsible for the political repression during which hundreds disappeared in the province. In this time, I questioned the explanations that could explain why Bussi was elected. Many researchers explain his victory as a victory of oblivion. In contrast, my hypothesis was that the voters recalled the order and the peace that Bussi established with blood and fire in Tucumán, and they consider positive the struggle against subversion that Bussi underwent. In contrast, another half of Tucumán voters refused Bussi because of his participation on the human rights violations. Battle of Memories, the vote to Bussi in Tucumán, was my first book. Reading of Maurice Albach's work helped me to respond to the enigma of Bussi's success. In 1925, Maurice Albach changed the way of thinking about memory. He argued that individuals do not remember in isolation, but as members of groups situated in space and in time, and that such group memberships give meaning to individual experiences through specific frameworks. He also posited that it was impossible to completely remember the past, as evoking involves selections that stem from present interests and values. Memory thus began to be viewed as a plural phenomenon, given the multiplicity of social groups, and the interpretation of the past lost its quality of immutable object that could be literally and privately grasped at will, to be understood as the result of political and cultural dynamics, and therefore of struggles to give meaning to the past. The above proposition helped guide research in the field of memory studies and helped me to understand that memory is in fact pluralist memories. Also, memories includes oblivion, and we can recognize memory struggles in connection with different points of view about the past, the present, and the future. After this, I developed a new research on the political history of the National Commission on Disappearance of Persons, CONADEP, and of its Never Again, Nunca Más report. I analyzed the process of production of Nunca Más, its content, and the history of the practices that explain its uses and resignifications. I examined the political process that framed CONADEP's investigation, how through the coordinated will of government authorities and the majority of the human rights movement, this commission was able to establish new knowledge on the dimensions of the system of enforced disappearances and built an unprecedented body of evidence to prosecute its perpetrators. On the one hand, I posit a new interpretation of the nature of CONADE, which previous studies on Argentina's recent history and international transitional justice literature had regarded merely as a commission of personalities that expresses the state's positions toward human rights violations. I argued instead that the success of the investigation and the Nunca Más report itself synthesized the combined efforts of the state and the human rights movement. In addition, I analyzed the interpretation of the country's political violence given by Nunca Más, the narrative style used in the report to expose the system of enforced disappearances and present the responsibility of its perpetrators. Finally, I researched the uses and resignifications of Nunca Más from its publication in 1984 until now. This analysis shows the political and cultural process that explains in what way Nunca Más gradually became hegemonic and as its narrative and interpretative approaches were reproduced in judicial forums, public discourse, political debates, and the leading cultural productions on the subject. In that process, different civil society groups presented their own reading of the political violence, disappearances, and dictatorship, using the Never Again report as a vehicle to do it. And finally, I posit that these interventions contribute to the canonical status of Nunca Más, and at the same time signified its meaning by introducing new interpretations that put into question certain premises of the memory regime configured by the report upon the reinstatement of political democracy in Argentina. Well, now I work on the process of construction of a public through and social memories regarding the system of enforced disappearances in connection with the judiciary knowledge. I try to examine the rhetoric and characteristics that characterize that truth and memories and their capacity and limitations to revealing key aspects of the disappearances whose examination will contribute to shape another kind of truth about this crime and the cycle of political violence experienced by Argentina 3 decades ago.
Thank you, Emilio. Certainly, I mean, your work, both your analysis, but also the Nunca Más report remains as a milestone for anyone working on enforced disappearances on the field of historical memory and transitional justice. Thank you so much for sharing this with us. And now let me turn to Barbara. Barbara, you, in contrast, are a lawyer from the United States. Share with us, please, what brought you to this field, and if you could please maybe elaborate on how you have experienced from that involvement the development of the concept of enforced disappearances. The floor is yours.
Thank you, Veronica. And I would also like to thank the organizers for focusing their attention on this important issue of enforced disappearances. It's an honor to be on this panel, and it's a pleasure to share it with Veronica and Emilio, who are both well known for their terrific contributions on this issue in the development of global standards and academic studies. I have worked in human rights since I was living in Chile in the early 1980s, where I volunteered with the Catholic Church human rights agencies, the Vicaria of Solidarity. And disappearances was one of the central human rights concerns of that agency. So as a young lawyer, I saw the issue firsthand from the perspective of the legal teams that were working there. And after moving to Minnesota, I was director of Minnesota Advocates for Human Rights. And I was intimately involved in the development of the Minnesota Protocol, which is a protocol for the investigation of arbitrary and summary executions, but also disappearances. It's, as many of you know, it's recently been revised in 2017, and it's intended to be a common standard of performance for investigating potentially unlawful death or suspected enforced disappearance. So it sets these international guidelines. But in addition to the Minnesota Protocol, one of our early projects at the Minnesota Advocates for Human Rights was an effort to file habeas corpus petitions on behalf of the disappeared in Guatemala. We also bestowed our annual Human Rights Award in 1987 on the grandmothers of the Plaza de Mayo, and their visit to Minnesota to receive that award had a profound impact on our entire human rights community's understanding of the intergenerational suffering that's caused by this crime, which has deprived, of course, countless families of the dignity of even knowing what happened to their family members. In recent years, my focus has shifted to the country of Mexico, and I've been working there for the past decade with many others, activists and scholars, on the enormous and complicated problem of disappearances. As you might know, the government of Mexico has acknowledged more than 86,000 disappearances in the past 15 years. So in my work in Mexico, I am one of the co-principal investigators of the Observatory on Disappearances and Impunity in Mexico, along with my colleagues at UNAM, the National Autonomous University of Mexico, and their Institute of Legal Research, and Oxford. And our aim is to apply academic methods to analyze available sources of information about the victims, the perpetrators, and state responses to these disappearances. So in terms of my observations of the developments in the legal developments and jurisprudential developments regarding disappearances, as Emilio's presentation has shown us, the Latin American experience has had a direct impact on the narrative framing of this crime from the very start, and also on the legal elements that formed the basis for the norm of prohibiting enforced disappearances. That impact was profound, even though we know that the practice of disappearance was a tool of repressive governments long before the era of Latin American dictatorships. The first UN General Assembly resolution on disappearances was adopted in 1978, even though it wasn't designated or wasn't specifically naming Argentina. It was clear that it was a direct result of the international community's concerns about that country, and the type of disappearances described in that foundational resolution were right out of the reports of the Dirty War, the CONADEP reports that Emilio is referring to. So as you described the current definition, Veronica, in your introduction, those core elements of that definition have been there since that foundational 1978 resolution. And the elements include three parts: the deprivation of liberty by or with the consent or acquiescence of the state or a party to armed conflict, followed by a denial of information about the whereabouts of the person. So despite this specificity of these origins in Latin America, these elements have successfully been applied by international courts and enforcement mechanisms in many diverse contexts, from civil war, authoritarian regimes, dictatorships, and now, unfortunately, in democracies. The crime is, of course, condemned universally in treaties and jurisprudence. The most recent treaty definition is the one that we use in our work, which is from the 2006 International Convention for the Protection of All Persons from Enforced Disappearance. But the same operative elements are found in various human rights instruments, the 1992 UN Declaration, the 1994 Inter-American Convention on Forced Disappearances, and the 1998 Rome Statute. Of course, the Rome Statute, as the people at Nuremberg will know, has particular elements, and some of those elements have that must be proven as crimes, individual crimes, and those elements are somewhat problematic in the human rights discourse around disappearances. So, whether in wartime or peacetime, the act of disappearing a human being is recognized as among the cruelest of violations. It's a crime that victimizes families and communities, as well as the direct victim. And many scholars argue that the prohibition is so well accepted that it has attained the status of jus cogens as a non-derogable norm. And the violation of enforced disappearance in human rights has two unique legal characteristics. It's composed of multiple violations, and it is a continuous crime. So let me just say a few words about each of those before I turn the podium back to you. An enforced disappearance consists of multiple violations of human rights, and each of these constituent rights has its own legal significance. Among the civil and political rights violated by disappearances are the right to life, freedom from torture, right to recognition before the law, and the right to fair trial. Because of these components, much of the earliest jurisprudence on enforced disappearances centers on the violation of these constituent rights, such as the right to life. So and even now, many advocates choose to bring human rights complaints to treaty bodies using the constituent violations rather than to prove the entirety of the definition of enforced disappearance. The Human Rights Committee at the UN just last month issued a decision in the case of Roy Rivera, a disappearance in the state of Nuevo León in Mexico. And that case used the constituent parts because, of course, the Covenant on Civil and Political Rights does not have a prohibition on disappearance specifically, but it has prohibitions on the right to life and freedom from torture. Less prominent in the jurisprudence about disappearances, but of equal importance to the victims, the disappearances also result in severe economic and social rights violations. These crimes completely undermine the victim's right to work, to care for their families, and to live healthy and sustainable lives. And of course, if we frame the victims as including the families, oftentimes the person who's disappeared is a significant, if not the main contributor to the family's economic support. So the second unique characteristic of the crime is that enforced disappearance is a continuous human rights violation. And states have not met their obligations with regard to these violations until the whereabouts of the disappeared person are determined. In 2010, the Working Group on Enforced and Involuntary Disappearances issued its general comment number 9 on enforced disappearance as a continuous crime. The working group relied on the articles on responsibility of states for internationally wrongful acts, and which in its Article 14 states that the breach of an international obligation by an act of a state having a continuing character extends over the entire period during which the act continues and remains not in conformity with the international obligation. That's the article from the Articles on Responsibility of states for internationally wrongful acts. So relying on that, the working group found that the act, which begins at the time of the abduction and extends for the whole period of time that the crime is not complete. So not until the state acknowledges the detention or releases information pertaining to the fate or whereabouts of the person. So because of this, one of the interesting legal characteristics of enforced disappearance is that that even if the person was disappeared before the state took on the treaty obligation, that if the state has not yet located the person or discussed the whereabouts of the person, they are responsible under the treaty obligation that they ratified after the initial event happened. And because of this, we find in several post-transitional states that states are in the position of having to address two categories of disappearance: historical disappearances from past regimes and current disappearances taking place in a different socio-legal context. So I'll stop there and we can continue our discussion.
Thank you, Barbara, very much, and such an inspiring career as well. I'm looking at the questions, and I'm happy you address at least partially one that Laura Barreto had on this continued nature of enforced disappearances. Laura was referring to particular cases in Latin America, in Colombia, where people are disappeared for a very short period of time, but then depending on how long that period is, sometimes it is argued that the disappearance actually never happened. So Laura, we're gonna keep this idea in any case in mind, and hopefully we can contribute with some ideas later on in the panel. Now let me move back to Emilio, and I think Emilio will help us also with one of the questions we have, which is about the relationship or the difference between genocide and enforced disappearances. And knowing your work, Emilio, I'm sure you could probably make reference to that through this question. So I basically want to move with this second question from the definition, which we now know, how it evolved both in Argentina and more at the international level, into what happens after. What happened in Argentina after the disappearances were acknowledged? And there was the opportunity to start, hopefully, searching for the victims. How was this process? And of course, from your own work and personal experience.
Well, it was a renowned American political scientist, Catherine Sicking. She's not an Argentinian scientist. Catherine proposed that Argentina went from being a pariah state due to the violations of human rights during the dictatorship to becoming a global paradigm for the promotion and defense of human rights. I agree with this idea. After the return of democracy, the state assumed the investigation of the disappearances. The country created the National Commission on the Disappearances of Persons, CONADEP, which investigate the fate of the disappeared, processes criminal responsibilities through the trial of the military juntas, and open trials after the repeal of the impunity laws. Issued reparatory laws for the relatives of the disappeared and survivors, disqualified perpetrators from holding public office, created the National Genetic Data Bank to identify minors appropriated by the repressors. 130 recovered their identity, and created the National Commission for the Right to Identity, CONADI, to locate them. The men's clandestine centers where the disappeared were held have become site of memory. School textbooks include human rights violation in their contents, and the day of the coup d'etat has been established as a National Day of Memory for Truth and Justice. These state initiatives counted on the commitment of human rights organizations and other civil society actors, such as the Argentine Forensic Anthropology team dedicated to identifying the remains of the disappeared. Well, in sum, the country has implemented all the transitional justice policies recommended internationally to ensure never again. What else could be done in this scenario? Well, I wish to share key aspects of the disappearances that are lacking from our historical knowledge and whose examination will contribute to shape another kind of truth about this crime and the cycle of political violence experienced by Argentina 3 decades ago. In the first place, we know little about the identity of the disappeared. CONADEP and the criminal trials restore the victims as human beings and subjects of law, but obliterate their political affiliations. Knowing the political affiliations of the disappeared will make it possible to establish the political logic behind the extermination, determine the proportion of disappeared activists who were official members of a specific organization and the organizations they belonged to, and correlate that information with their class profile, the place where they were abducted, and the institutional period in which they were disappeared, before or after the 1976 coup d'etat. That will in turn enable us to put into question the arguments that reject any radicalized affiliation on the part of the disappeared, and in particular any guerrilla connections, or that posit that most post-coup disappearances target social activists unrelated to guerrilla groups. Moreover, CONADEP classified the disappeared by their occupations, using non-mutually exclusive alternatives that combine occupational categories, workers, employees, specific occupations, lawyers, journalists, teachers, and generic occupational descriptions, professionals. While this resulted from insufficient information in many cases provided by the victims' relatives and friends, by presenting them in that way, the Commission also sought to highlight the whispered nature of repression. This information was never examined, despite the fact that the state has statistical instruments to do so, or can regate such data, a possibility that's increasingly threatened by the passage of generations. Such new data will help to establish the class profile of the disappeared, an aspect that is also key to understanding the logic behind their extermination. Well, lastly, the number of victims is still clouded by indetermination and political struggles. On the one hand, the indefiniteness of that figure is a result of the characteristics of the crime and the perpetrator's refusal to surrender the records in their power. On the other hand, it became a symbol fetish in the struggles between the human rights organizations that held up the figure of 50,000 disappeared to expose the magnitude of the extermination, and thus on the side of the repressive forces who relativized the number of victims. The numbers of disappeared recorded by CONADEP has in fact been modified throughout additions and eliminations. New reports were filed, especially after 1984, law granting economic compensations or reparations to relatives of the disappeared, and others were removed. Erroneously included due to spelling mistakes, duplications of women recorded under their maiden name and married names, survivors who had been recorded as disappeared, etc. Well, in this scenario, the survivors represent 27% of the total number of disappeared recorded, thus evidencing the selectiveness of enforced disappearances and distinguishing it from genocide. The significant percentage of survivors also merits examinations. Will CONADEP and the courts look for objective evidence in their testimonies and testimonial and biographic literature have made their memories increasingly available to the public, there are no analytical studies of their class profile, political affiliations, or even their distribution according to place of captivity and year of liberation. The perpetrators also constitute an unknown universe. The truth presented by Never Again and sought by the criminal inquest focus on establishing facts and identifying responsible parties. However, the life stories of the perpetrators, their class profile, and their ideas and values remain unexplored topics. We don't know how important the allegiance to the war against subversion was, if they had any real chance to disobeying orders without suffering consequences, and what role peer pressure or competitions and the desire for professional advancement, status, and personal profile play. Not much is known either of why and when the armed forces decide to turn clandestine examination into a state policy. While there are testimonies linking that decision to the desire to avoid the kind of denunciations that were being brought by the international community against the Pinochet dictatorship in Chile, to the Vatican's probable opposition to public mass executions, and to the advantages of a method without legal obstacles, we have a poor historical understanding of how that decision came to be and who participated in its adoption. The truth regarding the system of the disappearances presented the armed forces and the state as solely responsible. Thus, the criminal, political, and moral responsibilities of large economic, religious, and political groups were overlooked along with the responsibilities of ordinary men and women. Argentina set itself as a global model in the promotion of human rights because of the wide range and originality of the transitional justice policy it implemented following the return of democracy in 1983. In the course of this process, the truth about the human rights violations was constructed within the frameworks established by the courts. This made it possible to reconstruct the materiality of the crime and punish some of its perpetrators. However, there are key aspects to understanding what happened and which are part of an agenda for future research. If we know so little about the identity of the disappeared and the perpetrators, the genesis of the system of enforced disappearances, and the relationship that the various actors maintain with that system, it is possible that we may have overestimated the knowledge and truth we gained regarding this crime to say never again. It's a very interesting question, the lack of historical knowledge about this crime in contrast of the evidence that the courts receive and process.
Thank you, Emilio. It's really interesting to hear from the Argentinian experience because, as you were saying, despite its many positive steps that Argentina has undertaken to face the enforced disappearances, it is also a scenario that highlights the complexities of both the investigation and the search for the disappeared. And I think it provides the framework that you just shared with us provides a good scenario for Barbara to maybe go a little bit in depth into what really the legal framework helps or not the search of the disappeared. And I'm thinking of the fact that you participated in the elaboration of the Minnesota Protocol and how that document really provides fantastic guidance on all the international standards that exist to address both the investigation and the search, but that doesn't necessarily make it easier. What has been your experience, Barbara, in dealing with these two issues at the international level?
Thank you. Thank you, Veronica. And so the UN Declaration and the Convention on Forced Disappearances, it reinforced an existing obligation to investigate disappearances in a prompt, thorough, and impartial manner. And all the instruments that define and prohibit enforced disappearance impose a duty upon the state to investigate. But that obligation alone has not been enough to address the primary concerns of the families, which is, of course, the search, to be able to search and find their loved ones. And in the end, really, what has evolved since the Minnesota Protocol and the first versions of the Minnesota Protocol, looking at the requirements of disappearances, it is a parallel track, a push by families to recognize that there is also an independent need to search for and to presume that their loved ones are alive. So if you stop and address these two processes, you realize that the goals of the two are not the same. The purpose of an investigation, of course, is to determine criminal responsibility. The purpose of the search is to find the victim. And again, operating on the presumption that the victim is alive. This is extremely important to the family, as anyone, if you just put yourself in the shoes of these family members, you can understand that your first desire is to have the state to act quickly and effectively to help the family to find their missing loved one. So as that advocacy on behalf of families developed, it was clear that we needed to develop principles and guidelines for each of these parts of the process, the investigation and the search, and to explain clearly what was the state's responsibility with regard to each process. So in regard to search, initially, many prosecutors' offices defined search as just part of the criminal investigation, and they maintained jurisdiction over the search and often kept the families out of the search because they claimed that they were doing this as part of their criminal investigation. But the experience of the victims exposed the problems with this model, which of course succeeded in locating victims in very few cases. In some jurisdictions, even when there was strong evidence of a disappearance, police and other official investigators actually refrained from even receiving a complaint from families until the person had been missing for at least 72 hours. They actually had that embedded in some of their local and state laws, and that they wouldn't even receive the complaint and therefore wouldn't undertake a search. But we all know this is common knowledge in the human rights field, that the first 72 hours in a disappearance case are when the victim is most at risk. And so there was this counterintuitive sense that to treat disappearances like a missing person case and basically to victimize the families and the victim by claiming, oh, well, they've gone somewhere, they've headed north, or they're with their boyfriend, or whatever, in a different context might make sense, but in a context of generalized violence didn't make sense. Other cases in domestic situations have not been considered as disappearances. So the prosecutors would categorize the crime as kidnapping or trafficking or other forms of deprivation of liberty, which did not require of them the same kind of investigation and certainly didn't require search on a timely basis as part of those charges. So my experience in Mexico comes into the forefront here, is that the families in Mexico, in this situation where the prosecutors were not carrying out the search that they desired, they pressed for changes in the law, and they won a major legislative victory with the passage of the general law on disappearances in 2017, which not only required a search, but actually established a separate search mechanism, which is called the National Commission of Search. And that commission is an autonomous mechanism that is independent of the prosecutor's office, that it employs a distinct methodology for carrying out the search for the missing. And the process includes new definitions for disappearance, which include missing persons. So if a person is missing, but the family doesn't have evidence that it was part of a crime, the state is, and the commission is still accountable for initiating a search in these cases. And the process also created a space for interested parties to dialogue with the commission about its processes. And because these previous interactions had been so bad with the prosecutor's offices. And now in Mexico, as part of the law, there are 32 separate state commissions on search as well. So the international community, of course, has also responded to this experience of the families and the demand for search. And so the guiding principles for the search of disappeared persons were adopted by the Committee on Enforced Disappearance in 2019. And many thanks to Rainer Hooley, one of the speakers in this event, who was one of the leaders in that and came out of his experience of listening to the urgent actions and listening to the families. And those principles recognize the responsibility of states to search without delay. So Principle 6 says that as soon as the competent authorities become aware by any means or have any indications that a person has been subjected to disappearance, they should begin the search immediately and expeditiously. So it places the obligation squarely on the state to begin an immediate search. They also call for a differentiated approach to each case and recognize the rights of families, legal representatives, and indeed any person, association, or organization with a legitimate interest to actually take part in the search. So even with this international obligation to search, collectives of families, as we know, are often forced to take the lead in the search for their loved ones, who they call in Mexico their treasures or tesoros, as they carry out these searches at great risk. Now, in the area of investigation, there have also been significant developments. So while we have created this whole area on search, a new area of obligations on search, the area of investigation has developed as well. So the Minnesota Protocol was revised in 2017, and what was really notable is in the 25 years since the first version of that manual was published, the jurisprudence and the focus on investigation had developed substantially. So if you look at the revision, if you look at the two versions, the place where there's actually the most development is not in the scientific area of autopsy or police investigation necessarily, but it is on the obligation to investigate. And the revised protocol lays out the conditions that trigger the state's duty to investigate, which are in three areas. One is, of course, acts or omissions by state agents, including law enforcement personnel, or by non-state actors with the consent or acquiescence of the state. Also, the duty to investigate is triggered when the state fails to prevent foreseeable threats by non-state actors. And even in cases where the state agents did not evidently cause the disappearance, the state is under a general duty to investigate the case. So the guidelines are very clear. The state has to carry out prompt, effective, independent, and transparent investigation. And then again, specific, so the Minnesota Protocol, people think it's just about summary or arbitrary killings, but it also, from the beginning, has also included disappearances. But the Working Group on Enforced and Involuntary Disappearances has also just issued a very important report in 2020 on standards and public policies for an effective investigation of enforced disappearances. And those are specific to disappearance cases, where they note that impunity is a distinctive trait of enforced disappearances, and that's just that intersection cannot be emphasized enough. That impunity is the air, that the oxygen that gives life to these kinds of crimes, and so the working group is taking steps to be more forceful in setting forth standards for the state to investigate.
Thank you, Barbara. I'm just going to make one last question because we're running out of time, but I think I'll manage to bring together some of the questions that we have in the Q&A, and thank you everyone for your active participation. I mean, this is going to be the same question for you both, if that's okay. It seems clear from both your presentations and everything you have experienced and contributed to that we're not close to the end of the evolution of the concept of enforced disappearances. Warfare continues to change, contexts are different, and here, for example, Laura Barreto speaks about how enforced disappearances are now being used to, for example, present people, mainly young men, as success targets in war. And I'm assuming you're referring to those that are called false positives in Colombia, Laura, but also, of course, continues to be used as it was in Argentina as sort of a tactic against human rights defenders. And we have all these complexities you were talking about regarding the investigation and the search. So to address one of the questions of Professor Ariel Dulitsky, which is, what are the new challenges? What's coming now in terms of the evolution of enforced disappearances? Will you both address this question from your own fields, and what do you see as the future evolvement of this concept? Thank you.
Well, I believe that one of the challenges is to rethink the responsibilities in relation to disappearances. The issue of the responsibilities connected to the definition of the disappearance. Well, in Argentina, the understanding of the responsibility of the state in the system of the disappearance and the definition of the disappearance as a particular crime was not common even among the active accusers of the dictatorship. Well, this heterogeneity was the product of mechanisms of denial and disbelief that the experiences of extreme violence generate by violating moral frameworks and challenging the resources of representation. Specifically, the determination of the exclusive responsibility of the state in the disappearance system inevitably clashed with the ideological representation that proposed the state as provider of rights. Also, for an important portion of Argentine society, the armed forces represented the personification that ensured the establishment of order and moral values. Thus, for many, it was difficult to think that within the state, the armed forces were responsible for a systematic crime. In the same way, the public articulation of the system of disappearances, the kidnappings, and its clandestine phase, the captivity, torture, and the extermination of most of the disappeared, made it difficult to understand the system and to identify those responsible. Finally, the dictatorship promised to recover the monopoly of force for the state while denying the existence of the disappeared and in any responsibility of their fate. This discourse managed to be accepted even among those who made accusation of the disappearances based upon the fact that the coup took place in a scenario marked by guerrilla, state and parastatal violence, which delayed the universalization of the identification of state responsibility. Several members of human rights organizations and the relatives of the disappeared recalled the difficulty of understanding and becoming aware of the profile of the repression and the use of disappearances. They began to understand this later aspect when they found themselves complaining in police stations, courts, ministries, and other agencies. Even in 1978, when 90% of disappearances took place, many insisted on condemning terrorism of any kind, demanding that the state monopolize the use of the force. Indeed, the Communist Party argued that Videla represented the moderate sector of the army forces, which they contrasted with Pinochet. Doubts about state responsibility for disappearances also ran through non-governmental human rights organizations such as Amnesty International. In its reporting of 1977, which regard to the perpetrators of the kidnappings, torture, and murders, fluctuate in proposing that they were committed both by non-state groups and by official bodies, although it affirmed that they are overwhelming the elements of evidence according to which some disappeared persons are in fact being deprived of their liberty by the security services. In contrast, Argentina, the process to genocide, written by the NGO Argentinian Commission for Human Rights, qualified the crimes of genocide, proposing as his victims to religious groups, Jews, the Catholic Church, or professionals such as the press and journalists, and people working in education and culture, and linked the crimes with the economic plan of the dictatorship. The classification of genocide was based on interpreting that there was a victimization of specific groups, religious, ethnic, and social professionals, although the report did not provide evidence of this, but rather of a persecution carried out for political reasons. These views began to change after the September 1979 visit to the country by the Inter-American Commission on Human Rights of the American State Organization, after it had received hundreds of complaints of disappearances. The report, published in April 1980, described the disappeared as persons apprehended in operations that, due to the condition in which they were carried out and due to their characteristics, make it possible to presume the participation of the public security forces in these actions. In fact, taking the definition agreed upon that the human rights organizations that avoided, for reasons of political tactics, to hold the dictatorship fully responsible. Emilio Mignone, human rights activist, recalled that while some wanted to use the word kidnapping, which has a tinge of private action, others wanted to use the word detains that held the army forces as institutions responsible. Finally, the human rights organizations decided to use the word apprehended. After the Inter-American Commission visit, Mignone, already working at the Center of Legal and Social Studies, prepared a report, The Argentine Case, Forced Disappearances as a Basic and Generalized Instrument of Policy, the Doctrine of Global Parallelism, which was presented at the colloquium The Policy of Forced Disappearance of Persons held in Paris in February 1981. The colloquium was organized by the group of Argentine lawyers exiled in France and identified the tendency of states to avoid responsibility for disappearances, saying they came from uncontrolled or terrorist groups. Mignone's paper proposed the concept of state terrorism and dismissed that the disappearances were the work of out-of-control subordinates. When democracy returned, President Alfonsín ordered the trial of the guerrilla leaders and the military juntas and created the CONADEP to investigate the fate of the disappeared, and never again report presenting the system of disappearances as the result of the dictatorial state. Well, this representation silenced the political and moral responsibilities of the Peronist government before the coup, the representative of political and civil society in the disappearances, well, before and after the coup. This representation of responsibility in disappearances became hegemonic and only began to erode in 1986 on the 20th anniversary of the coup in the massive acts and its repudiation. Human rights organizations linked the dictatorships with the establishment of a neoliberal economic model and underlined the complicity of the Catholic Church, the judiciary, and the role of large companies in the COP, and its responsibility in the disappearance of union activists and leaders. A few years later, the trials for the truth accompanied this interpretative term. Despite not having criminal consequence and for the sole purpose of satisfying the right to the truth for those close to the disappeared, they exposed responsibilities of businesses of, among others, Ford Motors, Mercedes-Benz, unions, students, groups, doctors, nurses, and members of the Catholic Church. This new representation of responsibilities was enshrined as a state policy by the Peronist President Néstor Kirchner and his wife Cristina Fernández. Under this administration, the Congress made a decision endorsed by the Supreme Court of Justice to annulate the impunity laws that prevented criminal trials. Thus, the new trials transcend the institutional periodization that had been enshrined by CONADEP and the trial of the juntas that limit the responsibilities to the dictatorship in the disappearances, abandoning the identification of the armed forces as the only ones responsible, and in parallel, the representation of civil society as a group of either outsiders or victims of their crimes. These transformations were composing a more complex image of the disappearance system and its perpetrators, and open new questions about the behavior of the civil society under the state terrorism. In sum, the historical and political process of the development of knowledge concerning the perpetrators for the system of the disappearances reflected in the definition of the crime.
Barbara, would you like to add?
Thanks, Veronica. Well, looking forward, I think that there are two issues we need to, or two areas I'd like to talk about. One is we need to address disappearances in post-transitional contexts, including democracies. Unfortunately, or in several countries in Latin America, including Brazil, Mexico, and El Salvador, for example, disappearances may have actually reached higher levels than they did during the authoritarian periods or the periods of armed conflict in those countries. And so while the disappearances of the past and those that are taking place under these current democratic systems are not the same, we can see that there's social, political, and economic practices that make them, the social, political, and economic practices that make them possible are similar. So in our work on this, I've worked with Karina Ansolabere and Lee Payne, and they have identified four logics that bridge these different eras, the disappearances of the authoritarian period with democracies. First, the clandestine nature of disappearance to hide acts of violence. Second, the social construction of disposable peoples to avoid protest against such acts, so criminalizing the victim so that the public doesn't react negatively to their disappearance. The third is the political economy or utility behind the acts, how these acts fit into economic logics for the perpetrators or the society as a whole. And fourth, the use of ambiguous loss resulting from disappearance as a form of social control. So keeping fear and social control by the existence and the lack of resolution of these cases. But this all, of course, takes place in this context of impunity that we've raised before. And impunity creates the conditions in which disappearances thrive, whether the disappearances are carried out at the hands of state or private actors. And because of the difficulty of proving these cases within the existing legal framework on enforced disappearances, I argue that states have benefited from failing to expose, prevent, or punish these crimes. And in doing so, they've been able to hide the wrongdoing, to eliminate disposable peoples, and to promote their own political and economic self-interests, especially in contexts of macro criminality. So I would like to see a reconceptualization of the state linkage to crimes of enforced disappearance, especially in contexts of widespread patterns of violence. There is often collusion, clearly collusion in these cases between the state agents and criminal actors. But at a minimum, even when there isn't collusion, states should not be able to avoid legal responsibility for enforced disappearances through their own failure, incompetence, or delay in investigating disappearance cases. A relevant and effective legal framework would foreground the positive obligations of states to search and investigate these crimes. And we should use the generally accepted principles in the kind of standards that we've talked about, the Minnesota Protocol and the Working Group's 2020 report, to hold states accountable. In the working group's report, they go pretty far. They emphasize the legal principle that even if the state is not involved in the commission of the enforced disappearance through the collusion or acquiescence of state agents with non-state actors, the state breaches its obligation when not engaging in an effective investigation. But the problem, as I see it, is that finding a state in breach of its duty to investigate does not go far enough. Instead, I believe that in contexts of systemic crime, the state's failure to investigate is itself a form of acquiescence. And these cases should be viewed legally for what they are, enforced disappearances. While the international community has been hesitant to impose state responsibility in contexts dominated by organized crime, stretching this legal framework is necessary to disrupt the benefits that the states get from using dilatory or inadequate searches and investigations in these cases. These omissions amount to systemic impunity that violates the rights of victims, families, and societies, and creates a context in which these horrific patterns of disappearances thrive and families and communities suffer.
Thank you, Barbara. Thank you both. We run out of time, but I really trust we addressed most of the questions. Hannes, if I'm pronouncing your name correctly, Barbara just addressed a bit of the role of non-state actors. Sachin, if I'm pronouncing your name correctly. Thank you for thinking of the Latin American experience as one that could shed light on how to address this issue in India. And I just want to close by thanking, by expressing again my gratitude to the Nuremberg Academy and to the Center for Human Rights. I think you really managed to put together a fantastic and much needed event to address a topic that again is a concern for many countries around the world. The people that I can see as participants are fantastic colleagues doing incredible work to advance in achieving justice and opposing impunity for this crime and grave human rights violation. Emilio, Barbara, it has been an absolute pleasure. Thank you so much for joining me here today. I pass the floor to the organizers, and Eduardo, I'm very sorry we took a little bit more time than planned. Thank you very much.